My name is Tom Fitzgerald. I direct the Kentucky Resources Council, which is a provider of legal and technical assistance to low-income individuals, to community groups in the Commonwealth of Kentucky, and nationally on coal issues. We don't charge for what we do. We don't take fee-generating cases. So we have a very, delightfully unsustainable business model. But this is our third. We depend on the kindness of strangers. This is our 30th year, so we've managed to eke along, but just barely. Just so, in the interest of full disclosure, so you can completely ignore everything else I have to say after this, I wanted to give you a sense of what the sorts of things that we deal with on a daily basis. We get the call from the woman in Harlan County, which is as far east in Kentucky as you can go without tripping into Virginia. She calls and she says, "Mr. Fitzgerald, the state told me to call you." And this is kind of like, let's give it to Mikey, he'll eat anything. It's like, yeah, give it to Fitz. We don't want to deal with this. She said, "There's a man in a moon suit on the other side of the fence row from where I live." And I immediately understood somebody's in complete body containment. And he's putting dirt in a baggie. So she's describing, he's taking a soil sample. And I went over to the fence and I asked him what he's doing. He said, "Ma'am, there's nothing to worry about." She goes, and I just don't know whether to believe him. Well, so it turned out she had good reason to be concerned. It was the site, which is the Dayhoyt industrial site, a National Electric coil, ended up on the federal Superfund. So we get people when they're in crisis, and what we try to do is to help them get out of the crisis, to try to, if we can, teach them how not to be in crisis again. So we work with a lot of local governments, and we tend to get calls because we do things on a kind of a legal aid model rather than being a public interest law firm. Not that there's anything wrong with that. We start to recognize issues because we get calls. I started getting calls in late May about a proposed natural gas liquids pipeline. That is one of two competing projects that are racing to take the output of natural gas liquids from the Marcellus and the underlying Utica shales up in West Virginia and Ohio and Pennsylvania, because that's really where the profit center is now as opposed to the methane. And they want to ship it via, in Kinder Morgan and Mark West's case, they want to repurpose, which is a new word that will be in the dictionary next year. They want to abandon in place and repurpose the Tennessee gas line, one of their lines. The other project is the Bluegrass Pipeline Partners, LLC, which is Williams and Boardwalk being the owners of the Texas gas system, that want to run a new line from the producing formations through central Kentucky and tie in at Hardinsburg to an existing one of three Texas gas lines that they are also going to abandon in place. One of the really remarkable things about the Marcellus and Utica plays being developed the way they have is that you're no longer seeing the need for natural gas as much to come from the Gulf, because some of the eastern and New England demand is now being met from the mid-Atlantic states. So it's freeing up capacity and people are repurposing it. We also have a diesel line that's being repurposed by ATEX for running ethane up the Mississippi corridor. So I start getting these calls, and I put together about 20 or 25 citizens on a conference call, and I said, okay, I will take care of the technical and legal kind of framework. You all work on what's going on in your own communities, on educating your local officials, on talking to landowners and trying to sort out exactly what's going on. And what I found that really troubled me is as I started to look at this, the first thing I always do as a lawyer and a geek is go in and start to try to figure out what the framework is for these decisions to be made. And what fascinated me is the methane coming out of a well up in the Marcellus goes into a pipeline that is pervasively regulated in terms of its routing, in terms of the safety, in terms of the necessity for it. They have to get a certificate of need. The rest of the stuff that's coming out of the same well, the propane and the butane and the isobutane and the pentane goes into a separate pipeline, and nobody is minding the store in terms of the routing of that pipeline at the federal level. The closest you get is the Corps of Engineers, which in the case of the Bluegrass Pipeline is going to have 700 different stream crossings to deal with. So the question there is there enough federal control and responsibility here that you ought to federalize the whole project and do a comprehensive environmental impact statement? The only other federal agency other than PHMSA, who in our region I think has 22 people covering the entire southeast United States. When I talked to the guy and asked him some questions, he sounded a little beleaguered on the phone. Other than the standards that they set, which are, which they do spot inspections, but there's no permitting, there's no advance approval process. You have FERC dealing with the abandonment of the existing pipeline and the Corps dealing with the new line. But nobody is looking at routing and nobody is looking at siting issues. And so I started then looking at the state level. Well, some states like Minnesota have a siting board, right? And the flip side of that is many states that have a siting process also provide the power of eminent domain. Because unlike the Natural Gas Act, there is no federal right of eminent domain for a natural gas liquids pipeline that is in interstate commerce. Whatever powers they have arise, if at all, under state law. And we're currently embroiled in a little bit of a controversy over that with the Bluegrass Pipeline partners, and one that is very likely heading to court sooner rather than later because they're out getting easements right now from people. And I'm very concerned that some folks, with the fatalism that tends to afflict our state sometimes, people are thinking, they say they've got eminent domain rights. I'm going to cut a deal now because it's the best deal I'm going to get. If I don't cut the deal now, they're going to drag me into court. I'm going to spend thousands of dollars that I'll never see again to defend my right to be left alone. So we're going to try to take that off the table. There is a group called CURE, which is the Kentuckians United to Restrain Eminent Domain, and they just yesterday evening actually approved a litigation. And for those of you that like acronyms, we're dealing with Kentuckians United to Restrain Eminent Domain. So in their mind, the company has an ED problem and they're going to cure it. So so anyhow, so what I want to talk to you about is local government, is the role that local government can play. Kentucky is a state that has 120 counties. Okay? And because they wanted to make sure that everybody could ride to the county seat within one day. So we have 120 counties. We're the fourth poorest state in the nation. And there's a lot of reluctance in a lot of counties to planning and zoning. Typically, everybody has a little bit of reluctance to planning and zoning right up until the junkyard moves next door. Then they call me and they say, well, what can we do about this? I said, well, if you hadn't called the county judge a communist and voted him out of office or trying to get zoning and planning, we might have another tool that we could use here. Fortunately, in this case, you've got almost every one of the counties, in fact, I think every one of the counties along the pipeline pathway have zoning and planning. And the question is, for those of you that are working in multiple states, I understand there's a little bit of regulatory uncertainty because you are dealing with a bunch of different folks that you have to get approvals from and folks you have to work with. The Williams CEO recently lamented the lack of regulatory certainty. Unfortunately, my view of regulatory certainty is a little bit different. The view of AT&T that I've been dealing with because they're trying to deregulate phone service in Kentucky is their idea of regulatory certainty is the certainty of no regulation. Ours is a little bit different. It's the certainty of effective regulation. But we can both agree that in the absence of any overarching siting process at the federal or the state process, local governments are left to their own devices, and they are overmatched in many of these cases because they're not used to dealing with it. And so what we try to do is to help inform that conversation, to have them work with their local county attorneys to try to craft zoning processes that make sense, that are not arbitrary, and that are not preempted. Okay? In Kentucky, and this is going to vary by state, we have preempted local governments from doing anything dealing with oil and gas except for zoning. The reason that came about is because Chesapeake and Equitable were up in eastern Kentucky doing a lot of gathering lines, and it ticked off the county judge of Letcher County, Kentucky, who was one of the most forward-looking county judges I've had the privilege of working with, Carroll Smith. He's now back as an electrician in the mines. But he got run out of office for trying to pass a local ordinance on gathering lines, which go from the wellhead to the compressor station. So the industry's response was to come to Frankfurt, where the General Assembly meets, and preempt local governments. But the power under our zoning statutes was preserved. So you look first to see whether the state has preempted local involvement. In the absence of that, then you look to see whether the activity that's being proposed is subject to planning and zoning. And under our planning and zoning statute, Chapter 100, the structure can be regulated by the planning and zoning. A structure is anything permanent in or on the ground. So it doesn't fall outside of planning and zoning powers. Then you look to see if it is a type of activity that's exempted from zoning. Right? Many communities, many states exempt public utilities and public facilities from having to obtain planning and zoning approval. Because the Bluegrass Pipeline, for example, or for that matter, a merchant power plant, is not a public utility in most states, there is no preemption at the local level. Then the question becomes, what's out there in terms of models? Well, I was shocked to find, and I really appreciate the Pipeline Safety Trust doing the work that they do, as well as the Municipal Research Center, Service Center, because that's all that's really out there that I've been able to find addressing this interplay of pipelines and local planning and zoning. There's a lot out there dealing with existing pipelines and new development. Right? Because, one of the major causes of pipeline failures happens to be third-party encroachment. Right? There's also some structural issues with the pre-1970 lines, but you're dealing with trying to assure compatibility of nearby uses. What I've suggested, and I have a copy of it that I'm going to send to Rebecca, and she will send to you all electronically, because apparently the Wi-Fi is down here, and I couldn't print out a copy, couldn't get a copy to her before the session. Is there are a number of recommendations that have been made by the Pipeline and Informed Planning Alliance, which was PHMSA's response to the 2004, was the 2004 report by it was 2000 report, a special report by the Transportation Research Board of the National Academies, which suggested model ordinances, setbacks, all of these issues be dealt with. Well, unfortunately, the Pipeline and Informed Planning Alliance work to date has dealt with existing pipelines and new development. But many of the things that they identified, one has to accept, I think, that just as keeping incompatible land uses away from existing pipelines, the flip side of that is true, and that in routing a pipeline, there are certain areas that should be avoided, not just subject to more stringent standards. One classic example in what we're dealing with the Bluegrass Pipeline is they are proposing to come through a significant amount of mature karst. Now, karst is a terrain that is extremely unstable geology. It is characterized by solution channel flow, where the water is actually not flowing through the interstices or the pores in the rock, but is carving channels and dissolving channels through the limestone or dolostone formations. And this is an area that is extremely vulnerable. It is an area that has, for those of you who like bourbon, this is the source of the water for much of the bourbon that is produced in Kentucky. It also happens to be the location of the Abbey of Gethsemane, which is where Thomas Merton spent most of his adult life. And it is also the mother house of the Sisters of Laredo. Now, why do I mention that? Well, because the Sisters of Laredo are a very activist group of nuns. And if you get on YouTube and you YouTube search Sisters of Laredo, you will find two things. One is a Mother Jones video about them and about their mission and about their values. But the other is a delightful little clip of the sisters showing up at the Williams Company Boardwalk PR session down in Elizabethtown and standing in the middle of the room and singing Amazing Grace. And so I'm thinking to myself, nuns, bourbon, what are you thinking? So, but the one wag wrote to me, and he said when a news article came out that said that the monks at Gethsemane, who are Trappists, and the Sisters of Loretto had no interest in having this pipeline come across their property. That area of Kentucky is called the Holy Land because it was one of the earliest settled west of the Alleghenies, very strong Catholic community going back to the late 1700s, early 1800s. And he wrote to me and he said, is this a case of friar restraint? Or is this a case of none shall pass? I wrote back and I said, well, it's either a case of Downton Abbey or it's evidence that the Bluegrass Pipeline project will never make it to the Holy Land. So So with that, I'm gonna stop. Beth has not held up the 2 minutes. I have not slopped over. I was told don't slop over. Essentially, and what the written handout will have in it, there are really two approaches that you take, and that I recommend to local governments. One of them is elegant in being straightforward and being well understood, and that is you do a conditional use permit. Now, those of you who are familiar with zoning, conditional use permits are permits that allow uses in certain zones, or it could be in all of the different zones, residential, commercial, agricultural, industrial, which are uses that are of value to the community, but without certain conditions can be a problem, can be incompatible with other land uses. And a conditional use process allows the tailoring of conditions to a particular project. So you're not overreaching, you look at the particular project, because all projects are not created equal in terms of the pressure, in terms of the size of the lines, in terms of the materials that are being transported through the lines. Our experience in Kentucky has not been that salutary. We have 38 miles of natural gas liquids line, and we had a major explosion in that line a few years back, destroyed 5 houses, sent 9 people to the hospital up in Ivell, Kentucky, in eastern Kentucky. So the concern is a legitimate one. The concern is a real one about routing in a way that you are avoiding, particularly with natural gas liquids, because it's not just an acute explosive hazard as you're dealing with natural gas, it can be significant enough. You're dealing with contamination of groundwater and soil. And Parachute, Colorado being a classic example, where 80% of what was released from an NGL line volatilized, and 20% of it ended up in the groundwater, and they're still stripping the groundwater. So contrary to what the BLM thought in their overland pipeline environmental impact statement, 100% of it does not volatilize. And contrary to what I think API has said, it just doesn't happen. Some of the lighter fractions volatilize, some of the heavier fractions will partition, and some will remain an asphyxiant hazard at low-lying areas, and some of it gets into the ground and groundwater. Because I don't think they'd be stripping, thousands of gallons of water there just for fun. The other approach, besides a conditional use process, which some communities don't like because it puts the decision-making in front of a board of zoning adjustment that typically is dealing with, can I get a variance for a 7-foot fence rather than a 6-foot fence? And, oh, by the way, would you approve this 24-inch natural gas liquids pipeline? So there's some communities that say, we don't know that particular board is going to be well suited, because this requires a certain level of sophistication. What is the area of concern? Okay, there are models that will tell you what the area of concern is in terms of groundwater contamination, in terms of spills. You want to stay clear of the safety issues because they are clearly preempted. But that doesn't mean your standards cannot indirectly affect those issues, such as the Fifth Circuit case that was mentioned, the Texas midstream gas case, where there was a setback for aesthetic purposes from a compressor station. And the company said, yeah, but there's a standard that says we have to keep those a certain distance back because of fire hazard. And the court said, that doesn't matter. The fact that there is a standard addressing fire doesn't mean they can't set a more rigorous standard dealing with something that was within their control, like noise, odor, aesthetics, those sorts of things. The other approach is a much more complex approach, and that is creating a linear zone that would be an overlay zone where someone would come in and they'd rezone the property along the route, and they would have certain predictable standards that would attach to that rezoning. That is more predictable for the company. It's more complex for the communities. Ideally, I'd like to see the second half of the equation that the Pipeline and Informed Planning Alliance was tasked to do, which is you've done new development, existing pipelines. Get the other half of the puzzle in place so we have the best judgments from a multi-stakeholder group, including industry, including local regulators, including PHMSA, and we can put together a model comprehensive ordinance to eliminate some of that regulatory uncertainty, but to do so while making sure that communities' interests in compatibility of land use, in the ability to evacuate institutional buildings, in the siting relative to ecologically sensitive areas, siting relative to emergency response facilities, all of those issues that PIPA identified with new development. Let's flip those around and start and come up with a framework that is a workable framework that communities could adopt. Thank you very much.